you, sir. Good morning, Mr. Chairman and committee members. My name is Anita Scott, and I am testifying on behalf of Texas Homeschool Coalition in opposition to HB 1511. First, I want to thank the author of the bill, Representative Hicklin, for her ongoing dialogue with Texas Homeschool Coalition. THSC is the largest statewide advocacy organization for homeschooling and family rights in Texas. We advocate for the interests of up to 700,000 homeschool students in Texas. THSC opposes HB 1511 because of our ongoing support of and advocacy for parental rights. Parental rights is not a partisan issue. I think we may all attest to that with the number of bills filed this session that are seeking to strengthen and codify parental rights. We view HB 1511 as inconsistent with those goals because of its presumption that a local municipality is better equipped to make decisions for a parent's child than the parent themselves through the enactment of a juvenile curfew. To enforce juvenile curfew, in essence, ignores the U.S. Supreme Court case decision, Troxel versus Granville, which affirmed that parents have a fundamental right to make decisions concerning the care, custody, and control of their children. This case reinforced parental rights under the Due Process Clause of the 14th Amendment, emphasizing that the state should not interfere with the fit parent's decision regarding their child's upbringing without compelling reason. In reality, parents should be presumed to be acting in the best interest of their child. Not only does enforcing a juvenile curfew potentially violate the Constitution, it also does the following: misrepresents local law enforcement who were sworn to protect the citizenry against criminal activity, but instead creates new criminal activity, creates warped relationships between society, the justice system, and local law enforcement because children become hardened toward police when they have been stopped, questioned, detained, and fined for being a certain age and out in public. Innocent until proven guilty can quickly become a facade and less of a reality for youth living in a city with a juvenile curfew. The third reason is that it assumes that being a certain age and out in public is alone a sufficient enough reason to have a child interact with the criminal justice system. The fourth reason is that it may provide a child with his or her first interaction with local law enforcement, but not for committing a crime that harms someone or damages property. THSC has worked on this issue locally since the 1990s, and in 2023, we worked on HB 1819, which removed the ability of local municipalities to enact juvenile curfew, and this bill passed the House with 114 votes in favor of it and was sent to the governor to become a law. Not a single law enforcement agency or association testified in 2023 in the House committee. In lieu of enacting juvenile curfews again, THSC believes that there are alternative strategies that can be used to strengthen the culture of a city without increasing the chances of youth interacting with local law enforcement. And I have some of those strategies, and I'll be more than happy to provide those with you if you would like. Some of those include identifying factors that contribute to juvenile curfew, enhancing youth engagement, offering the public a list of variety of safe and free late-night recreational opportunities. Finally, many studies have shown that there is no correlation between enacting juvenile curfew ordinances and decreasing juvenile crime. For this and many other reasons, I urge you to side with parental rights and vote against HB 1511. Thank you for your time and consideration. And with that, I close and welcome any questions.
Any questions for Ms. Scott?